Thanks so much for joining us today for our HR Club focusing on mediation. I am the lead HR consultant and one of the directors at NQHR. My colleagues Simon Martin and Sarah Carrington are going to be talking to you today about mediation. But before I pass over to them, I just wanted to let you know about the next HR Club date. So our next HR Club is after the summer on the 14th of September, and it is going to focus on restructuring. So at the moment, we're supporting lots of clients with restructuring exercises, and we will do a session around that with one of our colleagues from VWV, the employment team at VWV. So we will cover off both the legal aspects of restructuring and any redundancies that might flow from that, alongside some of the really practical issues around how we manage that in day-to-day restructuring exercises. So,
sorry to butt in. There's a couple of chats saying that people can't hear anything. Is that something?
It could be their Wi-Fi, because I can hear clearly both Caitlin and yourself. So
right. So
maybe they just
others
need,
right. Okay.
Yeah.
Fine.
If they log out and log back in again, that might work. Sorry
to butt in.
Everyone. Do let us know if there are any problems, but it sounds like most people can hear. So for anyone who missed that bit, I was just saying that our next HR Club is on the 14th of September and we'll focus on restructuring. So I'm going to hand over now to Sarah Carrington. We're going to run through the mediation session. I will keep an eye on the Q&A box. If you have got questions, I will put them to the speakers at an appropriate point if I can. We have got a lot of people here, so we might not get through every question, but if we can't, we will try to cover that up in the follow-up that we send after the session. Thanks very much, and I'm going to hand over to Sarah.
Good morning, everybody. I hope everyone can hear me, and apologies for my croakiness this morning, so please bear with me, especially if I have a coughing fit as well. So this presentation is about the do's of mediation. There are some don'ts, but mainly do's. Simon and I are passionate about the benefits of and the uses of mediation, and we hope by the end of this presentation that we've won you over. So the first thing for you to do, there's a poll. So if you could please answer the poll, and the question of the poll that's on your screens now is, have you been involved in formal procedures at the workplace to try and resolve conflict? Okay, and those results are now coming through. So 79% of you are saying that you have been involved in formal procedures, and 19% are saying you haven't, and 1% not sure. Okay, brilliant. Thank you. That's really helpful. Next slide, we'll have a second polling question for you. And the second polling question for you to answer, please, is, have you used informal conflict resolution at the workplace? And that's coming through really high. So a yes of 83%, a no of 12%, and a not sure of 6%. Brilliant, thank you. Okay, next slide, please. So the agenda that we're going to cover today includes the costs of conflict, using grievance or mediation processes, mediation in practice, when to use it, the role of the mediator, both internal and external, and the NQHR mediation approach. Next slide, please. The cost of workplace conflict. Most of you will probably be aware of this that came out in May 2021. It was an ACAS report estimating the cost of workplace conflict. And what they found was that in 2018-19, 9.7 million workers experienced conflict, and the cost to the economy of that was 28.5 billion. Next slide, please. And broken down, what ACAS found was that 12.8 billion of those costs were down to formal HR procedures, of which I think about 10.5 billion were disciplinary. 11.9 billion, I think, was about 500 million resignations were down to resignation costs, and the finding that people leave their boss and not the job. And 2.2 billion costs was the attributed sickness absence costs. As ACAS found, about 9% of the cases of conflict, people took sickness absence. 74% of the people who responded actually said that they had used mediation and it had resolved their issue. So the people that used mediation, 74% had found it helpful. Next slide, please. So Mahatma Gandhi said, peace is not the absence of conflict, but the ability to deal with it. And that's what we'll be looking at this morning. So there's always a choice as to which route to go down. And high functioning teams need both conflict and collaboration. Conflict can bring energy and focus to a team, but when it's negative, it needs to be dealt with in a constructive way. And we've all heard people say, if only we had dealt with that earlier or nipped that in the bud, we'd probably all come across issues in our teams that we hope they would just go away. Sometimes they do, but not always. And that's when we need to have a good platform to intervene that moves issues on in a win-win and no blame way. And what the ACAS report found was that workplace conflict can lead to stress, anxiety, depression, and it impacts productivity and turnover. So formal grievance procedures excuse me, can be punitive. They can lead to other processes. They're traditionally adversarial. If you have an issue with someone and you find yourself sitting across a table with other people, what feels like a very adversarial process, that's not going to make anyone feel good. They can be retributive. They often lead to counter grievances and more hurt experienced by all parties. They are costly, both with time and the people needed to be involved. So if you think about it, there's maybe an investigation, there's interviews, statements, hearings and dates to be fixed, people accompanied to hearings, notes of the hearing, outcome letters, and possibly appeals. So it is resource consuming for all involved and stressful. And they are often a short-term fix. The outcome is decided, it's told, and there's no discussion or ownership. Next slide, please. Informal conflict resolution, of which 83% of you said you'd use, which is brilliant. There is more demand than ever for informal conflict resolution. #MeToo, Black Lives Matter, COVID, and returning to the workplace post-pandemic, which now has led to a reported increase of 1/3 in workplace conflict due to changed expectations and behaviours, plus now the cost of living crisis. They have also shown political aspects of society that impact the workplace. So why mediation? It's voluntary. The mediator will check at every stage that all participants are there voluntarily and are okay to continue. The mediator creates a safe space for everyone. It is efficient, takes just over a day, maybe less, and just involves those who are in conflict. It is flexible as to how it is arranged and the time needed. Everyone is heard and everyone listens. It is win-win. It's not about attributing blame or being a victim. And it's effective. Outcomes are agreed and owned, and therefore they are more sustainable and have a better chance of long-term success. And if needed, formal processes can still follow. Next slide, please. Mediation in practice. So what is it? It's a structured, facilitated conversation with a neutral third party, the mediator. For those involved, they can articulate what the issue is, and the mediator can help them with this. They are heard, which for many is all that they need. Everyone has uninterrupted time to tell their story and explain what they are seeking. Everyone listens and can focus on hearing someone without concentrating on their response. Everyone can express needs and goals in a constructive way. Again, the mediator can help with how to best present this. Hurt will be shared. The focus is on clarity and movement, that is getting unstuck. There could be an agreement reached. It may not always be necessary, but there's an opportunity to reach an agreement on next steps or actions. Next slide, please. So who is involved? It's just the people in conflict. It could be two individuals or it could be a group working with the mediator. It is confidential. No one else is involved. No one else is privy to that conversation. The conversation stays with the parties. Neither manager nor HR are informed of the content. Next slide, please. Any agreement reached is confidential. The parties may agree to share it, for example, with their manager, but only if everyone agrees to this. If someone does not agree, then it simply does not happen. And the mediator destroys any notes at the end. There are no records kept. Okay, I'm now going to pass you to Simon for more about the process of mediation. Thank you.
Hello, everyone. So we're moving on to the structure of the session. So looking at the structure, so the question is, why is it done like this? So when people come to mediation, they sometimes arrive with angry, unstructured thoughts. The analogy that I think is apt is that they come to mediation with various sort of shopping bags full of crumpled laundry, and through the individual initial meetings, they get those out. The mediator helps them get them out. They identify the key matters, and they fold them up into a smaller, more manageable sort of flight case or suitcase. And it's that suitcase that gets presented when the joint meetings happen. So we'll return to the concept of the angry laundry analogy later on. So hold that image in your mind. If the initial meetings have been effective, then the joint meeting will be more positive. There's less risk of it being a slanging match. And because often if there's quite a lot of criticism, the temptation is to become defensive and respond with criticism. So if the initial meetings can turn it into a more positive message, then there's less likely of it descending into that sort of slanging match. So the morning individual meetings are often where the most important work is done. So people often come with what are described as positions or demands. So John, they'll say things like, John's a bully. I can't work with him again. He singles me out for criticism. I want him to be dismissed or moved. So the mediator will be asking that individual, what do you want to achieve today? What do you need the other person to do and stop doing? And how would that look? So with statements about John's a bully, the mediator might ask, well, how do you think that will be received? Will that help you get to where you want to be? They'll ask them to focus on the behaviors that upset them and what changes they want. They'll try and remove the word bullying. And so they're asked to present a statement, prepare a statement that'll be read out in the afternoon session. So the second morning meeting, again, is confidential. It's just an individual meeting with the mediator, is them reading their statement, and the mediator will be asking questions about how that statement is going to be received. So the mediator will be listening to what they say. They'll reflect it back to them, but not verbatim. So they'll say things like, so what I'm hearing is that we'd like X to happen. You want X to happen in the future, that you want John to stop doing this and you want John to start doing that. So moving on to the afternoon session, the first thing to say is it's a voluntary process. This is something that the mediator should be reminding the attendees of throughout. In the initial meeting, that there's often a pre-meeting call, and again, it's front and center. You make it very clear this is a voluntary process. So there's no requirement to attend the joint session, but the experience is that most do. So in that afternoon session, the key is it's uninterrupted speaking and then listening. And so the other person is required to listen respectfully. The mediator will remind them of the ground rules of mutual respect and mutual listening. The idea is to create a safe space where each will be able to speak and listen to, and then after that, you'll move on to, if the parties want to, obviously it's their choice, the mediator will assist them with reaching an agreement, checking whether it's achievable, whether it's specific enough. The mediator will be asking questions about, does it cover this issue? Does it cover this issue? Is there anything else you want to be included? I think one of the key things, though, is the mediator doesn't suggest anything, doesn't try to fix it themselves, doesn't run those meetings. The mediator facilitates those meetings, but it's for the parties to reach those conclusions on their own and reach any agreement on their own. So next slide, please, Ella. So this is where mediation can be used. The main area where mediation is useful is where a formal grievance has been raised or is about to be raised. Often it's best used early in the process before positions have become too entrenched. Sarah talked about the sort of traditional grievance model, and it's often something that's recommended at the end of an investigation. We do a lot of investigations, and it's something we often recommend. But the issue with that is there's often been a lot of hurt caused by them, because you'll be putting comments made by the aggrieved to the person they're accusing of whatever they're accusing of. And so there's often a lot of sort of hurt and upset at that stage. And it can be difficult to unravel. So I think the general message is the earlier the better, because it's easier to unravel issues. And there's less of that angry, unstructured laundry that I mentioned earlier. So next slide, please.
Simon and Sarah, could I put a couple of questions to you before we move on to your next bit? So we've had one question coming in saying, if one colleague wants to engage in mediation and feel that they will struggle to work without it, but the other colleague doesn't, how should that be managed beyond trying to persuade the colleague who's not so keen to engage?
Well, my view is that's the only thing you can do. It's at the heart of it, it's a voluntary process, and so both of them need to be there. You can explain what are considered to be the benefits. You can explain, the sort of 80 to 90%, depending on the figures you look at, 80% to 90% of the cases mediation is successful, and you can ask them to think about what the alternatives are. Is it something, is a formal grievance process something that you would prefer to do? Because often that can be quite damaging, and so I would say that it's just trying to encourage them. But yes, it's got to be the case that they are there voluntarily if they do attend. You can't force them to do it.
Thank you. And then the other question is, have you had a situation where one party wants to attend, wants others to attend as support? And what's your view if that request has been made? So can someone bring someone along with them, basically, to accompany them?
I would say, Sarah might have a view on this, but I would say probably not. The idea is it's just because particularly the morning sessions is just a conversation, a safe conversation between the mediator and the aggrieved person. So each individual person has their meetings with them, and again the joint session, if you get that far in the afternoon, is a safe space where the mediator is there to control it, and they will step in if things become heated or it becomes disrespectful. So I think it's not going to be particularly helpful, I would say, to have someone there, because it starts to feel a bit more like a disciplinary or formal grievance process. So I would suggest probably not, although I guess in some cases you might want to, but I think that would be as a sort of last resort. If that's the only basis on which someone would attend, Sarah, do you have a view on that?
Yes, I totally agree, Simon. You know, it is about having a conversation with normally two people, and it's not a formal process where you have the right to bring someone, etc. It is about having a good conversation. So I think up front it would be about talking to both parties and explaining the process and basically reassuring them. And as I said, at each stage, the mediator will like check in with all parties just to make sure that they're still there on a voluntary basis and they're feeling okay. So I think it's just about explaining the process, but no third parties after the mediator.
I mean, where mediation isn't really suitable is effectively there's potentially it's quite a serious disciplinary case. So if there's someone's been accused of, it's quite serious bullying or harassment, then that's quite that probably isn't suitable to get someone people together in mediation. And so the other thing is the mediator can step in and stop a mediation session if effectively it turns into a bullying situation within, and the rules about respectful listening, etc., are being breached. Then the mediator may have to stop a session during the mediation process. So that's something just to be alive to. It's not suitable in all cases. Where mediation, I think, is best suited is where there's been effectively a breakdown in communication. Mediation, I think, is quite useful for the parties to try and resolve that and come up between themselves with a better way of communicating. That's the sort of classic area where mediation in employment context works best. So next slide, please. So just reminding you of the core principles of mediation. A mediator is impartial, they're non-judgmental, it's a voluntary process, it's self-determined. The mediator is just there to facilitate discussions, and the fifth core principle is confidentiality. So what happens in those individual sessions stay in there. So for instance, in those morning sessions, those separate morning sessions, the mediator is not acting as a go-between. They're not passing information to the other. It's not shuttle diplomacy. They're not going backwards and forwards saying, well, they've said this, so what are you saying about that? That should not be happening in mediation. So what the mediator is doing is they are gently challenging what each individual is saying on the basis of, will that assist you to be able to move forward and achieve the resolution you want? And so reframing what the individual is saying is vital. So if someone says, John never listens to me and always ignores the work I do, the mediator will be saying things like, so what I'm hearing is you felt the work you did on that occasion wasn't recognized, and you would like John to recognize that particular work. So how can you achieve, and you put the question back to them, so how can you achieve that, do you think? It's worth mentioning that it's just worth reminding you that most breakdown in workplace conflict is a breakdown in communication. So it's really useful for mediators to be focusing on that, about how can you achieve better communication, how can you improve your communication, and what do you want the other person to do when they're communicating with you. So next slide, please. So the mediator is encouraging each individual to come up with ideas. You'll ask questions like, so you've got a magic wand, how would you make things better? How would you like your working relationship to be with that person from now on in an ideal world? How would you like to resolve this? And evaluating, you'll ask them questions about, how would that work in practice? So it's Monday next week, you know, how would you like John, so you're in a meeting, how would you like John to address you in that meeting? And is there anything else that can assist? And so it comes back to communication. You know, it's testing about how these people want to communicate and how they want to be communicated with. And so you're asking the questions, and so the mediator is not there to fix anything. They're just there to ask the questions about how would this work for you? How would you like it to work for you? So next slide, please. So the mediator doesn't take sides, make judgments, or make suggestions. So you won't be saying like, oh, that sounds like John did the wrong thing there, but what you can say, and I think as a mediator, you can say, well, you know, I can see that episode what you're describing to me has really upset you, and so it's tempting as a mediator to say, well, why don't you try this? But that's not the mediator's role. The mediator's role is to allow the parties to arrive at these solutions themselves. So you will question it. So how do you think that will work? What is there that you could do that could improve that? How would you like? What would you like to say to the other person? Because in the individual morning sessions, you are building up to the afternoon session where they're going to be talking directly to the person they've got their problems with, and so you're putting them in that mindset of what do you want to say to them, and what message do you want to give to them, and how do you want to ask them to do things differently. So next slide, please. So internal mediation processes. So a number of our investigations have arisen in part from poorly done internal mediation processes. So what I'm talking about here is untrained mediators trying to resolve internal disputes. So these are usually well-intentioned or frustrated manager gets two colleagues together who are having difficulties to sort of try and knock their heads together and argue it out. So they often make lots of suggestions trying to fix things. One employee might think they were taking sides, and possibly employees are told that they need to attend. So just reminding you of the core principles of mediation. So the mediator needs to be impartial, non-judgmental, it's a voluntary process, and it's self-determined. So probably that internal quotes mediator has breached those four. And then to complete the set, the fifth principle of confidentiality is then breached by the one or both of the angry parties to the mediation. And so why would they be angry? Well, the problem is it's too early in the process. If the manager hasn't done those initial meetings, those initial stages, what you've got is both employees arriving in that meeting with their angry bags of disordered laundry, you know, the various shopping bags, and they're just put together. And so where they're at is just they're stating their positions. They are just venting their anger at each other. And so they'll be making lots of demands, and there'll be lots of hurt and fairly extreme statements. And that's likely to provoke a fairly defensive and hostile response. And things escalate quickly. And certainly some of the most sort of heightened and probably toxic investigations that I've done have come on the back of one of these quotes mediation processes, because it really inflames things, because the work hasn't been done getting the parties to a position where they are ready to talk in a more positive, structured way, and they're just venting their anger to each other, and that is likely to lead to problems. And the other problem is that when we do investigations, one of the typical recommendations we make at the end is these parties need to engage in a mediation process. And the problem is, if one of the problems has come about because of this mediation, it's sort of damaged the sort of mediation brand, as it were, because they're going to be less inclined to want to go back through that. It's a process they found, you know, upsetting, damaging, because it wasn't done properly. And so it's unfortunate. It creates quite a lot of tension, and it means that they're unlikely to want to go back through mediation. And it's quite difficult to say effectively, we'll do it better next time, and that wasn't proper mediation. That this next one will be proper mediation. So it can create some real problems doing it that way. Now, obviously, if the person doing that meeting has been trained and they understand the process and they've gone through those initial meetings to get their parties to the right place, then obviously that won't work. But certainly the ones we've seen, I've seen quite a few of, it's more just get them together and try and effectively knock their heads together and try and get them to resolve it. That often doesn't work very well and can be quite can lead to some quite unfortunate results. Next slide, please. So the narrow key mediation approach is the first thing we would do is we would have a conversation with the mediator, so with the person to assess if the mediation could help. And then what we would do is we would follow the process that I set out early. So what we do is we have a check-in call before the day to explain what's involved, explain the rules, the principles of mediation, particularly the one about it being a voluntary, self-determined process, check they're willing to attend, answer any question, and then prepare them for the mediation session. So tell them that the way that it will go and what the structure of the day will be. So that will be the that's the initial call. And then next slide, please. On the mediation day itself, we've already been through the process. So each side so the mediator assists each party to work through their needs and plan what they want to say. When they're ready, the mediator brings them together. Now, as I mentioned, that there's no obligation on them to do that, and it's a voluntary process, so they can stop at any stage. But the experience is that most people do tend to want to go through. And then an important bit is if an agreement is reached or the process is concluded, often agreement is reached on the day, or sometimes on the day or two after, the mediator will often then follow up, and certainly our approach would be to follow up with the parties at agreed intervals, so up between 1 and 6 months, say after 1 month, after 3 months, after 6 months, to check in and see how things are going, and if any issues have arisen. Because as I mentioned, one of the main issues is around communication, and so the parties might agree and put it in writing that they want to have a weekly meeting, a check-in meeting, where it might be structured, where they go through certain issues and just so they both understand where they're at, and so there's no misunderstandings. And it might be after a few months those meetings have started to slip a bit and a couple are being cancelled, and it might be that one or both parties are a bit concerned about those, and so it might be the mediator might have a sort of a quick catch-up call with them, and that the parties could then agree to put those things back on track or amend the meeting schedule. But it's quite useful just to sort of check in to see how things are going, and if there's any tweaks or anything that the mediator can do to assist them to keep things back on track. So next slide, please. So the question is, how can we help? And I'm now going to pass back to Caitlin.
Could I just put another question to you and Sarah before we get onto that?
Yes.
So we've had a question asking, can someone from HR be the mediator, or does it need to be an external person?
I think it can be someone from, I think, provided they've been properly trained, then yes, anyone can do it. I guess the problem is how well known they are to the individuals. If one has got sort of an ongoing relationship in the sense that one of the aggrieved parties has already had quite a lot of meetings with the HR person, that there may be a concern about that they sort of know too much, and there's that sort of ongoing relationship, and there's ongoing issues there. So, but there's nothing to say that they can't do that. But I would recommend that if they are going to start doing that, they get trained and try to avoid jumping into the process too early, because I think there's a temptation to jump into the process too early.
Brilliant.
Yeah, and I think to add to that, I think having been in that situation, sometimes you kind of know too much and you've got your own opinions. Yeah. And as an HR person, I think there's a real pressure on you to fix stuff. So sometimes it's more helpful to have an external mediator who kind of is totally impartial, doesn't know any of the background, etc., and just works with the two people in the space that they're in, or the group of people. So there's pros and cons of using internal and external people, but just to bear that in mind.
Brilliant. If anyone has got any other questions, if you want to pop them in the Q&A or the chat box. One thing I was just going to pick up on, Sarah, something you just mentioned, is whether it's appropriate to be used with groups of people where there have been fallouts, which is something that we quite often get asked to look at in terms of perhaps teams where the dynamic isn't working brilliantly. Is it an option in that sort of situation?
Yes, I've been involved in group mediation. I mean, it obviously takes much longer because you have to speak to each of the parties. But yes, it's helpful for either when two people are in conflict or there's a group of people. Usually it's a group of people and their manager. But yes, it's helpful to use mediation in those forms, because everybody then can be listened to, can be heard, can say what they need, and they're not in a formal process, so people feel more able to say what they need to say.
Brilliant, thank you. Any other questions coming in? Please feel free to put some in, if into the chat box or the Q&A, if we can help you. Otherwise, Ella, could you move on to the next slide, please? So we've just put this in to ask that if anybody who's on the session would find it helpful to have a 15-minute call just to discuss any mediation needs, we're really happy to do that. So if you just want to let us know, then we can follow up with you. So Sarah and Simon are both accredited mediators, and it's one of the services offered by NQHR. So if that would be helpful, do let us know. Give people a moment to vote on that. And then when the votes have come in on that, Ella, if you could just move me on, let me just see if there's anything else that's come in the chat box. So we've just had a question for Sarah and Simon saying, can you recommend a training organisation that does mediation training?
There are various organisations. Some are very expensive. They're all quite expensive. So Simon and I were both trained basically using TCM. There's Consensus. There are various organisations. If you're looking for an organisation, then I suggest you just look at what they offer, what they cost, and obviously some of the feedback that sort of people post about how they found the course.
And there's sessions that can be run that are run that sort of are to explain the mediation process, and there's which are usually sort of a day or two, and there's ones where they to train you to be a mediator, and they're both useful. But obviously, if you want to be trained, then they tend to take longer. I think our one took 5 days with various, and there's quite a lot, probably about a day or two's homework to be done afterwards.
And I'm sure Sarah or Simon would be happy to have a quick call to chat to anyone who's got any particular queries about how it was. We've had another question coming in. Any thoughts, considerations about who goes first, especially when mediation timetables are set quite tightly? I've heard participants complaining about going second and not getting a sufficient break, and also complaints about going first for other reasons. So is there a particular order? Is it something to be discussed and agreed? How does it generally work?
I mean, I'd be talking to the people in their sort of meetings during the morning or like whenever those sort of sessions are heard, as to this kind of sequencing and when they want to go. I think normally it's the person who has probably raised the issue that would go first. So they've been listened to, but I think it just really depends on the issue and the people that you're dealing with, and I'll just discuss it with them. And yeah, I mean, I think, as we said, it's flexible. It can take any amount of time. So sometimes you'll need longer than a day, and I think it's not to rush it. It's to actually give those people the opportunity to have that conversation, and not to kind of cut it off if at all possible. But obviously that is sometimes tricky.
Yeah, and it depends on how many issues and how much that each individual person wants to bring to that formal session. The idea is you're working towards a statement that takes sort of 5 minutes to read out. But if someone's got a lot they want to get off their chest, the mediator won't stop them from doing that. They'll ask questions about how useful do you think that would be, and what are you hoping to achieve. But ultimately, it's not the mediator's role to say no, you can't do that. The mediator is there to sort of gently challenge about what they want to say. But yeah, it's not, I think, given the rules about the sort of respectful listening and sort of safe time, I don't think it should matter that much, because each side gets their own opportunity to speak and to respond to what's being said. So by the end of the mediation session, both parties have had the opportunity to sort of go, and because the mediator isn't a judge, they're not going to sort of say, yes, I decide in your favor, you're the nice one, so there's none of that. So it's just for the parties to try to achieve an agreement. So I don't think I'm not sure it should matter as much, because if it's done properly, everyone gets the same go.
Brilliant, thank you very much. I think that's all we've got on questions. So Ella, if you could move us on to the next slide, please. So this is just to chat very briefly about some online training sessions that we have produced along with our colleagues at BWV. So you'll see on the slide there are a whole range of topics. They're sort of bite-sized training sessions with some bits in about the legal aspects, and also some practical stuff around how you manage things day to day. They are available for a fixed fee for your organisation. If you would like any further information about those, please just let us know on this slide, and we will contact you to talk you through or give you a demonstration of what they look like. That would be really helpful. Thank you. And then if you could move on to the next slide, please, Ella. And to the next one, please. So it just remains for me to say thank you very much for joining us today. Thank you, Sarah and Simon, for taking us through that topic. Please do let us know if you have any queries. We will follow up with the recording and with a copy of the slides. And if you would like to have that chat with either Sarah or Simon, do please let us know. We're very happy to do that. If you could just give us some feedback about how you found the webinar today, that would be really helpful. And hopefully we'll see lots of you on the 14th of September to talk about restructuring. Thanks so much. Bye-bye.